It's the same system you use for the court.
This meeting is being streamed.
Okay. Ladies and gentlemen, dear friends, colleagues, good morning to all of you and warmly welcome, and thank you for joining us for this launch of a new report on the digitalization at the court. My name is Krister Haglund. I am a director of the Nordic Council of Ministers office here in Estonia. As the Nordic Council of Ministers representative in Tallinn, it is my great pleasure to moderate this hybrid event, which takes place live here in Courtroom 222 at the Tallinn Circuit Court, and in the spirit of today's theme is transmitted live to all of you joining us digitally through the court's own conference system. Let me first say that I am by no means an expert on today's topic. I have actually never spent time in court, but instead quite a lot of time on court with a tennis racket in my hand. So my role today is purely technical. Our office here in Estonia was founded some months before Estonia regained its independence in 1991. So we celebrated our 30th anniversary last year. In the beginning, we assisted Estonia in building up its society and institutions, but during the years, the cooperation has evolved and is now on an equal level. We share experiences and learn from each other. On the sector of digitalization, Estonia has often been a forerunner, and I think that we will get examples of that here today when we are launching a report that was commissioned by the Nordic Council of Ministers for Justice with support from the Nordic Council of Ministers for Digitalization. In the Council for Digitalization, Nordic and Baltic ministers work together to make the Nordic and Baltic countries digital forerunners. An important aim of the report is to promote development of the digitalization at the courts in the Nordic Baltic countries by facilitating mutual learning. The report can also be useful for practitioners who work with cases in the courts of other Nordic and Baltic countries. So I think that this is a very good example of the Nordic-Baltic cooperation. Professor Frederik Waage started his work on this report before the COVID-19 pandemic forced us all into digital meetings. It is clear that the pandemic has spurred the digitalization of our societies in general and the public sector in particular. One of the benefits of the report is that Professor Waage has been able to include this perspective in his assessment. At this seminar, we will hear Professor Waage presenting the key findings of the report. We will also get additional perspectives from members of the advisory board of the project who are joining us from the University of Uppsala in Sweden and from the University of Iceland. But first, Director Kaiti Lippus from Courts Division at Ministry of Justice in Estonia will give us an exclusive insight in the digitalization of the courts in Estonia. You are most welcome to put forward questions and comments to the speakers, but I will ask you to save this for the questions and answers session towards the end of the event. If you are participating digitally, I will ask you to use the chat function for your questions and comments. I hope I'm not spoiling too much of the suspense ahead of Professor Waage's presentation of the findings of the report when I say that Estonia is at the top of the class when it comes to digitalization of the courts. We are therefore particularly pleased to be here at the Tallinn Circuit Court and to introduce Mrs. Kaiti Lippus. She has been the director of the Courts Division in the Ministry of Justice here in Estonia since 2016. Mrs. Lippus will tell us about the digitalization at the public administration and the courts in Estonia. Kaiti, the floor is yours.
Thank you. Hello everybody here in Tallinn and in virtual room too. At first, I would like to thank the Nordic Council of Ministers and Universities for researching the court's digitalization and launching this report. I am grateful for the organizers for choosing Estonia and this beautiful historical courthouse in Tallinn as a venue of this event, and giving me opportunity to introduce Estonia's system and share my views about digitalization. I work for the Ministry of Justice in the Courts Division. My team consists of 8 people, 8 competent, hardworking and dedicated women. We are responsible for distributing resources among the courts and courts registers, drafting laws and regulations considering courts and developing courts ICT. Developing information systems and digital tools is a hard task, packed with obstacles and stress, but it pays off. I truly believe that digitalization is a way to strengthen the rule of law and the key to improve the justice system and judicial cooperation. And since the war in Europe was started by the Russian Federation on February 24th, I also see the digitalization of public sector as a security guarantee and state's obligation to its citizens. The report on the state of digitalization at the courts in the Nordic countries and the Baltic States gives us really good insight into the digitalization of courts in those countries. According to the report, Estonia is the most developed country in this field among 8 Nordic and Baltic countries and received the highest grade 7. Actually, at first sight, I only looked at the grades, and to be honest, I was quite doubtful. I thought that there is so much work to do and achieve in the courts digitalization. We, servants of the courts and court users, feel every day that we have not provided enough. We are dreaming of smarter, quicker, and more user-friendly ICT solutions. But when I read the report carefully and thought about the criteria which were essential and important for the rating, I agreed. The current level of courts digitalization in Estonia corresponds to the expectations to those criteria. During my presentation, I firstly plan to say a few words about the digitalization in public sector in Estonia, and then I'm going to talk about the court's ICT more precisely. So, first I describe the most essential building blocks of e-Estonia and most successful e-services. e-ID and ID card. All Estonians, no matter where they happen to live, have a state-issued digital identity. This electronic identity system is called e-ID, and it has existed for 20 years and is the cornerstone of the country's e-state. e-ID is part of any citizen's daily transactions. People use their e-IDs to pay bills, vote online, sign contracts, shop, access their health information, and much more. Estonians can use their e-ID via ID card or using mobile ID on their smartphones or the application Smart ID. E-governance. An Estonian citizen experiences government or e-governance primarily through the services we receive. In Estonia, almost all public services are available online 24 hours a day. There are some exceptions, of course, for example, marriages and divorces. Estonia has reached an unprecedented level of transparency in governance and built broad trust in its digital society. Estonia is the first country in the world to implement e-voting in a nationwide election. Which was first, iVoting or trust? It has worked both ways, I guess. We vote electronically because we trust the digital society, and we trust digital society because we even have experienced iVoting. There have been 12 elections where the iVoting has been possible since 2005, when 2% of the voters chose this method. Last year, during the local government elections, the percentage of e-voters was 46. Another success story and essential part of e-governance is e-tax. E-tax is an electronic tax filing system. Each year, around 98% of all tax declarations in Estonia are filed electronically. Further, innovative e-solutions are the core of the Estonian healthcare system. Each person in Estonia that has visited a doctor has an online e-health record that can be tracked. E-prescriptions is a centralized paperless system for issuing medical prescriptions. All health information, medical test results, X-ray pictures are kept in person's digital health record. A person may give access to its medical data to any doctor or hide it in the system. Parents can access their children's health records using e-ID. Citizen-centered state and service-oriented society requires information systems to function as an integrated whole. There must be interoperability between different organizations and information systems. The X-Road software-based solution is the backbone of e-Estonia. Invisible, yet crucial, it allows the nation's various public and private sector e-service information systems to link up and function in harmony. State information systems are different, but they all rely on X-Road. To ensure secure transfers, all outgoing data is digitally signed and encrypted, and all incoming data is authenticated and logged. X-Road has been available more than 20 years. Luckily, X-Road was designed with growth in mind, so it can be scaled up as new e-services and new platforms come online. I have read that Finland and Iceland and also Ukraine are using X-Road's solution too. Dear participants, as you may understand now, the base for developing e-solutions for courts and encouraging people to use courts' digital solutions has been solid and supportive. There are great ideas and digital enthusiasts, good experts and brilliant solutions for the courts in many countries. Our development in Estonia has just been a little bit quicker thanks to the e-governance and its base. Now let's turn to the main issue, courts digitalization. Here you can see the list of the most important IT solutions for the courts and court users. We have created a digital environment where all the steps from initiating a court case to a final decision can be taken electronically. Court hearings can be done online as well. Thanks to these solutions, our courts had been able to carry the work with minimal disruption during the pandemic, and despite the challenges of the pandemic, actually more cases were opened and closed in 2020 than were in previous year. Public e-file is a portal which allows procedural parties to electronically participate in proceedings in civil, administrative, criminal, and misdemeanor cases. Public e-file is based on the e-file system that combines the information systems of the police, the prosecutor's office, the courts, and other bodies conducting proceedings, ensuring central sharing of proceedings information between parties and the quick and paperless data exchange. In the public e-file system, communication between parties takes place only via the X-Road I talked about earlier. All judges and court officials use the court information system KISS, which is also accessible for distance working through a secure VPN connection. All documents submitted to a court or generated by a court are registered in the KIS. For any particular court case, all documents, each procedural step, and received or generated data are registered in the KIS. The court office scans all paper documents that are sent to the court to be saved digitally in the KIS. The KIS is also an environment for creating court documents, making inquiries from other databases, and sending court information to other information systems via e-file. Court statistics are generated by the KIS and made available to judges and court managers. The KIS is also used for distributing cases automatically among judges. Cases are registered, and the case characteristics, such as a case type or a number of the defendants, are entered in the KIS before distribution. Algorithms are used to ensure an equal distribution of workload and distribution according to specialization of judges. All court orders and judgments are digitally signed by the judges in the KIS and are considered to be original and authentic. The court judgments are published digitally in State Gazette Riigi Teataja since 2006. Digital Court File is a new ICT tool that enables a better view of court files for judges, court clerks via the KIS, and parties to court proceedings via public e-file. Digital Court Files offers users several options for better organization of their work, such as sorting documents, marking necessary documents, commenting. User-friendly Digital Court File is essential for the judges for giving up the paper file. We just launched new version of Digital Court File, and we continue to improve the system further together with IT developers and several judges till all judges gonna use it and value it. At the beginning of 2020, our IT company was adapting Cisco virtual meeting rooms, which we are using right now, for using them in the Ministry of Justice and in other organizations for having meetings when the pandemic started. Within few days, the virtual rooms was launched both for the ministry and for the courts with extra elements for the video court hearings. It is cross-platform software and works in video conferencing equipment, PCs, laptops, tablets, smartphones. It is encrypted and matches with Microsoft Outlook. Virtual court hearings were widely used during the pandemic, and now some judges continue to use them. All court hearings in Estonia must be sound recorded, and the sound files are part of the court file and accessible via public e-file. For years, courts used Liberty Court Player solution from Canada for that purpose, but now we have our own recording system, Salme, which also enables automatic transcription of court hearings. So the typing will soon be forgotten, and making the minutes will take considerably less time in the future. The basic functionality is ready, but we just started improvement project as court clerks would like to amend the automatic transcription during the hearing, not after that. Courts have received new laptops, monitors, video conference tools, and matrix systems for operating all the equipment. The first systems are outdated already, and the list of the urgently needed new hardware is quite long. We really hope to make a development leap in this area within a year now. Long is also the list of needed and urgently needed new IT solutions. The next big news from Estonia justice system will be fully digital, way smarter criminal procedure. We have to move on with reducing the use of digital documents and increasing the use of structured metadata. We are looking for opportunities for optimization and automation of court's procedural steps in every types of procedures, including procedural decisions where possible. We will start with those solutions step by step. We will not try to develop brand new courts information system, new KIS, as the task would take too much time and parts the system would be outdated before the end of the development project. We have realized that we need simple digital solutions even if the procedure itself is complicated. We encourage the courts to harmonize their processes in order to have better, more user-friendly, easy-to-learn ICT solutions. And I will conclude my presentation with a list of important elements while trying to achieve next level in digitalization. It all starts with government, which truly supports the digitalization, and with leaders who understand the digitalization and its usefulness and are really ready to make an effort and even fight for it. Big ideas, but realistic planning with sufficient budget is needed. Nowadays, you also need that certain level of cybersecurity is met in your organizations. It is not possible to be successful in digitalization without it. And last but not least, you really need to value the real persons working hard every day, step by step towards the better future, better digital solutions. So keep them happy and near to you. Thank you for your attention.
Thank you, Kaidi. This was a very useful overview. You will be staying with us until the end, so if there are any questions for Kaidi, you may ask them later. We will now move on to the presentation of the key findings of the report presented by Professor Frederik Waage. Frederik is a professor of constitutional and administrative law at the University of Southern Denmark, and he is the main author of the report. Frederik, the stage is yours.
Thank you very much. Thank you. Dear employees of the court staff at the Tallinn Circuit Courts, representatives of the Estonian government and the Nordic Council of Ministers, members of the advisory board of digitalization of the courts, and ladies and gentlemen out there. Here in the second decade of the 21st century, digitalization has an impact on most areas of our lives. Douglas Engelhardt, the famous inventor of, amongst others, the computer mouse and hypertext, once stated that the digital revolution is far more significant than the invention of writing or even of printing. Along with the introduction of the personal computer since the beginning of the 1980s, the ordinary conduction of office tasks has been transformed within the public as well as the private sector. For many years now, citizens in the Nordic and the Baltic States have become used to electronic case handling when communicating with their governments. This has led to a great variety of initiatives which aimed at taking administrative case handling as well as administrative case law and all areas related to administrative law into the digital era. But in sharp contrast to the overall picture of digitalization of administrative case handling, courtrooms and court administrations were, for many years, remarkably untouched by the general trends of digitalization. The modest level of digitalization at the courts appear to have been more profound in the Nordic states compared to the Baltic states. And there are historic reasons for that. Reasons which seems to resonate higher today than they did just a few months ago when this report was finalized. In the years after the fall of the Soviet Union, Estonia, Latvia, and Lithuania seized an unique opportunity to make digitalization an integrated part of the design of their new-built institutions. The Nordic states were obviously not eligible to build new institutions from scratch at the dawn of the digital revolution in the 90s. Regardless of the historic developments, it is mainly within the last decade that courts in the Nordic and the Baltic States have opened for a more thorough digitalization of their court systems. And this short study, Digitalization at the Courts, it aims at establishing an overview of the technological developments and the current level of digitalization at the courts in 8 Nordic and Baltic countries. Focuses especially on the case handling portals, which today in various shapes set the frame for the ways in which parties go to court in the examined countries. Let me briefly turn to the report here in my presentation. The report includes a ranking of each of the countries, which was just mentioned in the earlier presentation. And just to make it quite clear with the ranking, our ranking in the report is based upon an overall comparison of the digitalized case handling at the courts using the following criteria. The existence of a case handling portal and the functionality of that portal, opportunities to communicate with the court via digital equipment, the degree of use of technological equipment at the courts, e.g. video interrogations and sound recordings, and access to open source online court case law has also been a main criteria for ranking the countries. This is not a perfect and overall ranking of all the aspects of being a digitalized for digitalized court systems. In our report, we don't have a technical approach. In fact, our report is to try to sit in the seat of the judge and see which facilities are available in each country. And therefore, it should be noted that the purpose of the ranking is to describe the functions and the functionality of the different digitalized case handling systems, seen exclusively from a user perspective. In the ranking, we have not focused on more closely on, e.g., safety issues and relations concerning operational reliability or other criteria which surely has a significance for the technological development. And that would be the purpose of other studies. This study, the aim of this study is simply to see how far has the digitalization brought us in the ordinary work at the court, especially from the judge's point of view, which facilities are basically available and how does that, in order to come up with some conclusions that may describe how the courts simply work with these facilities. Let's have the look at the countries at a glance, which is a very brief view of the different countries, and I can refer to the report, which is available online now also. Here we see the trends. Basically, you can see that Estonia, Latvia, and Lithuania performs very well. This is not a competition. We found it useful to make this rating. There are good qualities in all of the system when it comes to digitalization. Estonia is just slightly ahead of Latvia, and we have not made a very specific ranking as to that, but I can confirm that is the case. But they received both grade 7 because they have very developed systems. Latvia is almost implementing some parts of elements of digital case handling. I'll get back to that. I can refer to the report. Let's start with the Baltic States, since they perform so well. In Estonia has for many years been considered the digital frontrunner in government, and this is also the case when it comes to its use of digital equipment at the courts. In Estonia, written material related to all proceedings are digitalized, and they can be accessed through the e-file system. And judgments from all courts are published on the Riga Chapter website, which has a comprehensive source form. The COVID-19 pandemic prompted the use of more online court meetings. However, in the long run, the pandemic is not considered a real game changer for the already very digitalized Estonian state. That was a brief introduction to Estonia in my 20 minutes presentation. Lithuania. With the case handling system Liteko, Lithuania has a comprehensive case portal which gives the court and parties in litigations a wide access to almost all parts of the court system. In line with the two other Baltic states and in contrast to the situation in the other Nordic states, practically all parts of the written procedure at the courts has now been digitalized in Lithuania. In Latvia, the court proceedings have been underway for many years, and the court has communicated through an electronic platform since 2006. With the implementation of its new e-case system, Latvia plans to fully integrate case handling in the public sector with its court system. The COVID-19 pandemic has led to a major increase in the use of remote court proceedings where citizens do not show up in court. Turning to Sweden and Finland going west, Sweden currently does not operate with a case file handling system, which can be compared to systems we had here. However, a new portal for filing initial electronic claims has been launched in 2021, which has led to a significant improvement of access to court by digital means. And COVID-19 has led to more remote hearings using the court's video equipment. We'll get back to Sweden in a few minutes. Finland, already since the 1980s, the courts of Finland have used a number of electronic platforms in their case handling at the courts. And with the implementation of a new case handling portal, IPA for the ordinary courts and HIPA for the administrative courts, Finland has taken a major step forward in the digitalization of the courts. Since the outbreak of COVID-19, Finland has seen an increase in the use of remote digital video connections in the courtrooms. Turning to Norway and Denmark, Norway has taken a great leap forward with the introduction of Aktørportalen and Justitshof, both case handling systems which allow attorneys and other external users the opportunity to communicate directly with the court. And several new digital initiatives have been taken recently. Norway still does not have a public case law database. In Denmark, a relatively high number of tasks at the courts have now been digitalized. The introduction of the online platform Sagsportalen in 2018 and a new case law database which was launched in 2022, as well as new initiatives contribute to the development of a highly digitalized court system in civil cases, including administrative law cases. And the digitalization of case handling at the courts is less developed when it comes to criminal cases, which is one of the reasons for the current ranking of Denmark in comparison to the other countries. On Iceland, Iceland is the only examined country which currently does not have case handling portal or specific digital case filing system, initial case filing system. The courts are, however, very well equipped with all kinds of technological equipment at the courts. And it's also possible to safely submit documents electronically. Video conferencing has been widely used during the COVID-19 pandemic. We will hear more from Iceland in a moment. Digitalization is generally promoted in order to make case handling at the courts more efficient. It speeds up the process since ordinary mail is no longer used, and it reduces the administrative tasks for the courts as well as the users of the court, including private enterprises, the government, and private persons. However, it is important to note that electronic portals, such as the systems we have seen introduced today, are more than just electronic mailboxes. When parties have the possibility to present processed documents and send them to the parties in an intranet, in an IT system or a case handling portal, and when the parties have the opportunity to communicate through a system rather than using letters sent forward and back. Some of the classic characteristics of work with a legal case is basically disappearing. But a court case is essentially an exchange of information between parties and the judge. And the preparation stage of ordinary legal cases consists of an exchange of written documents which goes back and forth between the parties. It was traditionally done by ordinary mail. For several hundred years, the ordinary mail has set the frame for how the parties work at the courts, not least in a country like Finland, where written procedure is predominant. If one has a court which predominantly has a written procedure, and that procedure becomes digitalized, one must presume that there would be a special connection between digitalization and administration of justice. There's hardly any doubt that it will be less forgivable to miss a deadline if one has a computer which automatically notifies the parties of the deadlines. At the same time, errors which are made are eliminated when one has a computer which supports the case handling from beginning to end. Digitalization will therefore simply set higher standards for the proceedings and for the parties. When we see good examples of case handling systems which are very sophisticated, working very well, the future of case handling at the courts will be more efficient, deadlines will be kept to a greater extent, and costs will be kept down, and many elaborate procedures may be handled with more or less automatized processes. It is, however, interesting, and an interesting part of this study to discover that the individual countries that use artificial intelligence and algorithms in very sophisticated ways in their work, they don't use it to a greater extent. Artificial intelligence may be seen as part of, for instance, social anonymization programs or case relocating programs. And the technology may also be used as search algorithms and something that can be used for creating databases on case law. But aside from this, there is not much that suggests a further automatization of the process of the individual cause. It appears clear from the survey here and from the development at the different court administrations in that no courts are even close to implement a fully automatized process which can substitute a regular physical judge with a computer. The administration of justice is something very special, and the work in the court has a certain character, which makes it more difficult to make an automatic process, and thereby the court system stands in a different situation compared to general administrative law and to administrative decisions, which are often today made automatic. It has been an important part of this study to examine how COVID-19 has had an impact on the individual countries' initiative to work electronically. The study has not mapped out any major change following COVID-19. It is, however, clear that the COVID-19 pandemic has led to an increased use of oral meetings using a computer by Teams or Zooms or other communication channels, which has enabled video link and remote access to accomplish court sessions. And at least to some degree, this development is expected to continue in the future. Presumably after the COVID-19 pandemic is over, we will see that to a great extent, programs such as Zoom, Skype, or Teams will be used to accomplish court sessions. Finally, it's the hope that in continuation of this brief overview, further studies can be made concerning the digitalization and its significance for the work of the courts in the individual countries, and how far the individual countries have reached in the area of digitalization. Overall, this report provides an image of a technological development where the Nordic countries are well on their way to realize one of the goals in the previous Digital North program of the Nordic Council of Ministers. And it is an inspiration for all of these countries to look at a country like Estonia or the other Baltic states, which has gone so far in that direction. I think that would sum up my comments on the report, and I will look forward to dive into it in the Q&A session if we have possibilities for that. Thank you.
Thank you very much, Frederik, for your really interesting presentation on the situation in the Baltic Nordic countries when it comes to digitalization. And there will be, as I mentioned earlier, also an opportunity then later on to put forward questions and comments. We have also invited two of the members of the advisory board of the project who will provide some additional national perspectives. And I'm pleased to welcome Associate Professor Eva Storskrubb from the University of Uppsala in Sweden. Eva is joining us digitally from Sweden. A warm welcome to you.
Thank you very much. Can you hear me? The classic question of all digital communication.
Yes, we can hear you.
Yes. Thank you. Thank you very much. I'm very grateful for the invitation, and I was also very grateful to Frederik for the invitation to participate in the project or give input to the project. I think this is a very welcome project, and I also congratulate the University of Southern Denmark and also the Nordic Council on the report itself. I think it's a very easy read and a practical tool in the continued research and discussion on these issues, both at the kind of research level or more academic level, but also a practical level. And when it comes to procedural law, which I am associate professor of course, the practical level and the kind of research level or the academic level, I do personally consider significantly interact. And I've also, of course, myself worked in practice for a long time and only recently become a full-time academic. So I also have personally, in my own personal background, maybe a practical perspective. But I think that many of my colleagues would agree that in researching and working in procedural law, we do have the very clear connection with what happens on the ground in the courts practically. And my personal practical experience is as a counsel or an attorney. So I have never worked internally in a court or been in a sense seen the case from the inside of the court, working at the court, rather from the perspective of a user working as an attorney. Now, but very briefly, I think the court report in a sense accurately reflects the situation in Sweden to the extent that digitalization of courts has not been my understanding is that it has not been a forerunner of the Swedish issue of the Swedish government for a long time. However, I would say, which is not kind of said in the report, is that the current Swedish government has a very strong or much more focus on digitalization and a new kind of program on digitalization, which I haven't, at least myself, seen in the previous governments. And there is a kind of ongoing broader project to digitalize, further digitalize, I would say, the administration in Sweden. I mean, use of email, being able to email all official bodies and so forth and so on, in general has been available for a long time. And Swedish society is generally, of course, very digitalized. So I think, but the idea of creating special portals and the kind of portal system which has been introduced, for example, in many countries, in many Baltic countries, has not been a focus of the Swedish administration or the Swedish governments. But now I think there is a new kind of drive towards further digitalization or updating the digitalization that in Sweden of the administration in general, and including then the courts. But I would also say that from my perspective, what I can see from the outside is that much more, which is not either mentioned in the report, much more focus has been on the criminal procedure and criminal proceedings, and some of the interesting things that are in the pipeline. For example, an idea of an original digital judgment that could circulate digitally between all the relevant authorities is being launched for criminal cases first. So we have maybe a bit more focused on digitalization of the criminal justice system broadly, including the criminal court or the criminal proceedings and courts, the part of the court proceedings that are dealing with criminal matters, rather than the maybe the civil proceedings, which also take part in the general courts, or then the administrative proceedings, which take part in separate administrative courts. But we have had some new tools also introduced, which are also mentioned in the court. The new introduced last year, and the new case filing for civil matters, and more is in the pipeline. The idea that we also will have a standard digital claim form, maybe specific digital tools for specific matters such as divorce applications, and also this kind of digital file communication between the courts and the parties, which we don't have now today, on a platform. We have it in practice all the time via email still, but not this kind of platform or portal system we don't have yet. So developments are afoot in Sweden, I would say, which are maybe not all reflected in the report on what the current status. I think also if you think about the Swedish ranking, will probably change also quite soon in the future. And also, of course, I don't know to what extent the criminal developments have been taken into account from the Swedish side in the report, because they were not mentioned specifically. But that was maybe the main comments I had on the kind of report and the status quo in Sweden. What I would say as a researcher, I think, and I would say something also maybe about shortly just about the COVID, because the courts, as many of you know, we didn't have a lockdown in Sweden during the pandemic. We had no general lockdown during the whole pandemic. So the courts, in a sense, remained open, or did remain open. But of course, we had more digital hearings or more people being heard digitally and remotely. But this was also possible before the pandemic at the discretion of the court. The court also had the possibility before. It was not as common and not maybe considered appropriate or considered necessary. And this might, of course, change the practice on what is considered appropriate or necessary, how at the discretion of the court to use digital means might, of course, have changed with the potentially positive experiences during the pandemic. But there is no research showing also the future, in a sense, if we will, and of course, this is something I agree with Frederik, that it will be interesting to monitor in the future. How the courts will act with the discretion they already have to use digital means, if this will continue, and the court practice in this sense, the practice, not the legislation, will be cemented due to the pandemic. However, I would say there's a research from countries which had lockdowns and which had also very strict lockdowns, where the parties, attorneys, and court officials were all sitting in remote different locations and conducting digital hearings, some preliminary research shows, for example, that the parties, the actual, either the natural or legal persons, the company representatives of the natural persons, they felt, some research that I've seen shows that they felt less connected with the proceedings when they were sitting at home and when they were also not sitting in the same location as their attorney. And I think that also attorneys, the work with between the attorneys and the clients, it's certain such aspects of access to not maybe justice, but proper counsel might have been more difficult, even if these things were also overcome with using different chat actions and using maybe different other digital means. So it's not said that also either it's in the interest of parties or that the parties necessarily have considered the digitalization of court proceedings during the pandemic as something which you use completely all the time in the future. And we have this aspect of, having a day in court where not necessarily it's the same thing if you come to the court and experience the court hearing from your own living room or your own location or in the court, which is something is sociological research rather than also, in a sense, merely legal research can touch upon. However, these things, of course, how people perceive a digital environment, of course, also change over this time. Nothing is static in this sense. But I think we have to remember the different perspectives. What is very efficient from a court official might not be the same experience, or a judge or the court might not be the same experience for the attorneys who are and also supposed to work with their clients and protect their clients' interests, or from the perspective of the counsel, what is most good in the sense of being entitled to a proper hearing in court. And there is an interesting discussion going on in the hearing in Sweden, also in relation, which I won't go into detail, but in relation to arbitration, there is a case, I think, still pending in the Swedish courts in relation to what is the right to an oral hearing, or what is the right of a party to a hearing in the context of arbitration, which is then an arbitral award has been challenged in this context. And the idea that in this case has occasioned a discussion in Sweden about, is a party, if you are entitled to an oral hearing, what does the oral mean? And so that is, I think, an ongoing discussion in the context of digitalization. What is the party's entitlement to a hearing? If the parties, of course, for example, if the parties want to have also the hearing in court. So this is, I think, these are ongoing discussions, and interesting cases will develop also in the post-pandemic scenario. The pandemic scenario is one, particularly if you had a lockdown. But if you didn't have, and in the future, I think our opinions will probably change or develop, but it will be interesting to follow. I look forward to questions, and I hope I haven't taken up too much time.
Thank you, Eva, for your excellent overview of the situation in Sweden and the impact of COVID-19 on the procedures. We are actually ahead of time, but anyway, racing straight over to Associate Professor Kristín Benediktsdóttir from the University of Iceland. She will be offering us a presentation on the digitalization of the courts from an Icelandic perspective. Kristín, the screen is yours.
Yes, thank you so much. I will just yes. So, can you see the slides now?
Yes.
Okay, thank you. I just wanted to start with thanking you very much for the invitation to the seminar, and thank you, Frederik, for the participation in the project. It's very important for Iceland to participate in projects like this, even though Iceland is a very small country. It will help Iceland in taking these steps forward in digitalization, no doubt. And it will be helpful in pushing Iceland forward in digitalization as a whole. The court system in Iceland is not very big. As the Icelandic nation is small, Iceland is a small country. We have 10 courts and 3 special courts. The population of Iceland is around 350,000 inhabitants, so it's not a big country. We had, though, of course, we have these regular courts. These 10 courts are all regular courts in the sense that we don't have administrative courts. We are very close to the West Nordic countries. And the court system is very close to the West Nordic countries, Denmark and Norway. So we take a look at those countries, what they are doing. We take a look at their lawmakers, what they are doing for the courts, and then we take some steps forward. That's how it has been working for us here in Iceland. We had this major restructuring of the Icelandic court system in 2018. Then we established a court of appeal. We didn't have that one before. We had just 8 district courts and the Supreme Court. But in 2018, we established this middle court. So we have now 3 polars in the court. And as well, in 2018, we established the judicial administration. And then we went to this reopening of cases, and we established a special court on these matters in 2020. So we have been doing a lot of things here in Iceland for the court system and trying to modernize it more. And even though it has been working quite well, we have been doing that, especially we were thinking about the criminal cases. So they are working much better now, we think at least. But 2018, it has not been so many years since we started this new system. Even though we have modernized these 3 steps, a 3-pillar system in the court system, the digitalization was a little bit left behind. Of course, as we are a small country, we don't have much money. So we have to focus on one part at a time. The administration in Iceland is digitalized, but the court system has been left behind. Even so, we have started, and we did start in 2018 when we reconstructed the court system, and we have now the management system in the courts. The records management system is digitalized, and it has been since 2018, even in the Supreme Court, which was a little bit behind the district courts. And the digital communication is between the courts, mostly between the district courts and the Court of Appeal. So it has not started between these courts and the Supreme Court. So the Supreme Court is behind again there. So in this digital communication system, it's possible to access necessary data anywhere and anytime. And also it's possible to send documents to the Court of Appeal and the Court on reopening of cases by a safe server connection. So some steps has been taken, even though we don't have this portal like the other countries have. Even so, they send the documents through this safe server connection. All court files need to be handed in on paper as well. And then they need to be handed to the National Archive in the end. In 2020, when the COVID-19 occurred, it was a big step forward for the Icelandic court system. The procedural law, both in civil and criminal, were amended temporarily, and they have been extended this amendment to December 31, 2023. So according to this amendment, it is possible to have all court sessions on video conference system. And it has been used, and they are still using it even though the COVID-19 has gone down at the moment. So they really like it, especially in the district courts. They have these meetings. They are using it a lot. I would say, though, that the younger judges are using it more than the older. It's possible to submit evidence and case files electronically, but it also needs to be handed in on paper. So they have been taking steps forward because of the COVID-19. So actually, one can say that the COVID-19 was a positive, a positive step for the courts in Iceland. So it did push the digitalization forward. At the moment, the work has started on amending the civil and criminal procedural law permanently. So the courts are very interested in doing something about this and doing it more digitalized, even because they have been working on in a digitalized world. They need to do it. They have been pushed to do something about it. So it was really good, actually. And they have been working on special projects. The Judicial Administration and the Ministry of Justice. So they are trying to connect offices to a database. It was mostly in criminal cases to begin with, but they have started to do it in the civil law cases as well. So one can say, even though we don't get a good grade in the report, we are doing something at the moment, and it is a work in progress. We have started it, and we will finish it. That's a fact. But the cost is a big factor for Iceland. It's a really small nation, so we need to be clever when we are doing this. And we are watching and learning from our neighbor countries in the Nordic countries and the Baltic countries. There have been meetings, there are seminars coming up, and so on. They especially have been looking to Estonia and Denmark, I'm told. And we were looking at the pros and cons in this work. And as we say here in Iceland, good things come to those who wait. That's what we always say, but we try to do our best at least. Thank you so much.
Christine, thank you for your good presentation. And I would also like to thank all the speakers for their presentations and perspectives. And I have to say that I'm really surprised also and impressed that we are well ahead of our timetable. I don't think that I ever experienced anything similar before. But now we can then move on to any questions and comments. So I open up the floor for your comments and questions in case you have any. And for those of you participating digitally, please write your questions and comments in the chat function. So do we have any questions or comments already? Yes, we have some. Can you turn on the mic, please?
We have a question asking, is cloud service used in any countries for case handling or portal?
Frederik?
Yes. I must say that here we are at the border of at the borders of really what this project demonstrates. I think I would like to pass on the question to our representative from Estonia here as to Estonia, because this is the most advanced country. What we can say is that some kind of cloud service is surely used in a number of these countries, because otherwise you would not be able to perform the tasks which are covered in our report. So yes, cloud service is used to some extent, but we do not go into the details in this report. We look at the functionalities, but I don't know if perhaps you could explain whether to which degree you use cloud.
Yes,
yes,
of course we use cloud service, but I also can't go into details.
Yes, on the technical level, but it will surely be necessary, because when using the possibilities of online conferences, which were used during the pandemic across all of the countries, I would say that is one area where it's difficult to avoid that option. But that was one question. Thank you.
Thank you. And then we have a question here from Petteri Korhonen, Justice Court of Appeal from Finland, I presume, asking if it is possible in Estonia and other countries that a judge or one of the judges participates court proceedings via video conference outside of courtroom. And saying that in Finland, Supreme Court ruled that this is not possible. So we in Vaasa Court of Appeal arrange court proceedings in a way that all justices are in courtroom in Vaasa, and parties and witnesses are participating online instead of traveling 200-300 kilometers from the places of our district, if considered appropriate in the case. And he's also extending big thanks for excellent presentations. Thank you, Petteri. Would you like Kaiti to start?
Yes, thank you for the question. I hope that our Supreme Court will not choose this way to do that kind of judgment, because in Estonia it is possible, and judges use this possibility to have a court hearing in a video room, and they sometimes participate from their home office, not in courthouse.
I can say that from the Danish point of view here, the possibility of remote judges in that extent is not possible according to the Danish legislation. We have not experienced in our survey of the different countries. We have not. I've not come across concrete examples of courts that work this way, where you have a judge who is separated from the rest of the court. We had one interesting example, I can say, in Denmark with the Danish impeachment trial, which was quite special recently, because we had 26 judges in the case, and that happened almost at the end of the second wave of the pandemic, or just before actually the Omicron variant came out. So there were 26 judges who should not be ill, and it worked actually. It was possible in the autumn of 2021 to conduct all the hearings almost without any interruptions. There only came one interruption in the end, but at that time the hearings had ended and they were only deliberating. They were only voting for the verdict. So they were able to have the internal deliberations conducted with the judge on the remote. But there's also a right, and there's also The fact that you can look the judge in the eye, the fact that you can see the whole court, would, at least as far as I can say from a Danish procedural law point of view, not make it possible to divide up of the court in the hearing process, as far as I can see from here.
Thank you, Frederik. Would you, Eva or Christine, would you like to add something? Yes, please.
Eva, would you like to start?
Yes, just briefly. I haven't. This has not happened. To my understanding, this has not happened in Sweden for the reasons I mentioned in the report, and for the reasons that was not a pandemic. So all the court officials have all in cases have and at hearing stages have been available in the same courtroom, or then maybe in an adjoining room. But everybody has been at the court, but the parties and the witnesses have potentially been able to be online. But I also understand, even though I don't work at a court, I have understood anecdotally also that even in deliberations in chambers, in some courts and judges I've spoken to, they have also during the pandemic been obliged to come to the workplace. So there has not been a very much working remotely for the judges, as I understand it, at least in the courts that I've discussed with people, that they have also been obliged to, for internal deliberations and meetings, formal meetings, to come be physically present. So there has been, but I don't know if that's true for all courts or if that has been regulated in some way, or there has been any kind of internal practices. So that I can't speak about. But the hearings, that is my understanding.
Thank you, Christine.
Yeah, thanks. In Iceland, it has happened that a judge was outside of the courtroom, at least once in the Court of Appeal, and it was an external judge. That's what I was told, and I was a little bit surprised because I thought it was impossible. But then again, I was in the labor court yesterday, and I was told that it happened in the labor court too. That was a judge she's living in the east part of the country and couldn't fly over to Reykjavik. So she was online. But of course, the witnesses, the parties, they have been online. But at least I know of these two examples. But we don't have any judgment from the Supreme Court on this.
Thank you, Christine. Do we have more questions?
Yes, we have one more question, I think, from Iceland, and it's also a bit of a technical question, probably to Kaidi. The question is e-file in Estonia a separate database, or is e-file a group of web services?
E-file is the center of our system. It's it is a separate database which connect into it which the other information systems are connected. So we do have some data in courts information systems, but mainly all the data is in e-file system. And all the data of prosecutors' information system and prisons' information system actually is kept in e-file, in this centralized database. Does it answer the question?
I think so, and I think I could add just in continuation of this that one of the reasons why we ranked Estonia as performing very well when it came to the case handling portal is that we consider it very much integrated with the other administrative databases. That is a contrast to other countries in the Nordic and Scandinavian countries where where the integration between the administration and the courts doesn't perform well, where they're very, very isolated systems. when you get the idea when you go to Estonia, when you see their system, but they have the whole package. They have the case handle portal, and which interplays with the way you communicate with the rest of the public sector very well. We have similar development in Denmark when it comes to also the Danish case handling portal, which you connect to with NemID or MitID. But it's just a whole. You have sort of an approach in Estonia where I would say you have good connections between the systems.
Yes, maybe I would like to specify that e-file itself communicates with other databases like population register, and e-file communicates with, for example, population register via X-Road, via this secure channel. The inquiries are moving all the time between e-file and other state registers too. That you may say that it is part of the web.
Thank you.
Thank you. More questions?
Yes, we have one more. Also about Estonia's system, I think. The question is, could Estonia tell more about the e-file regulation?
Yes, every information system has its own general regulation. And there the rights how to use the information system is stipulated in regulation, not in law actually. In law, the e-file is mentioned, and there are regulations which in law which put some obligation to procedure parties, to persons. Then it has to be stipulated in law, in procedure law, not in regulation. But what concerns the information system e-file itself, then as e-file is not only for Ministry of Justice organization, but for also for internal affairs ministry's organization, then it is a regulation of the government. No. And I think if anyone is interested, I even could find the e-file regulation in English. I'm sure of it.
Could that be sent to the participants, perhaps, if you find it?
Yes. Yes.
Super, thanks. More questions?
Not from the chat, but I have a question. In your report, you conclude something about that the pandemic appears not to have had that much impact, at least on the future proceedings. And Eva had some points, and Christine also had some points about that. But could you perhaps elaborate a bit about why do you think that the future won't bring that many changes after the pandemic?
I certainly believe that when it comes to the use of Zoom and to the degree that that is allowed for in court proceedings in the work, just like the rest of the world is working more in that way, this will probably influence the courts. But most of these systems which we deal with, such as the e-case system in Estonia or the Danish case handling system or the Aktørportal in Norway, these systems, it takes several years to develop them, and it takes a long time of preparation and funding of the governments, and that is not something that that happens from month to month. It will basically take many years before you would see the COVID-19 having a significant influence on the way that the systems are structured, because it takes some time here, and you have not seen a need during the COVID-19, as far as we know from the latest conference we made, to take initiatives in the countries to make brand new systems or brand new way of working. And sort of the countries are, of course, to some degree limited to the systems they have. They might use electronic equipment for communicating more, may use video the more because of the pandemic. But what we can surely learn from Finland, many of the countries here, is that the funding of the government is of course crucial. It is crucial that there's a long-term investment in each of the developments. It took many years, as an example, to create a public database for case law in Denmark, only because almost 7 years ago, the Danish Parliament decided to spend money on this. Well, after 7 years, they got a case law portal. So it's just to mention, it takes many years before you can see the results, and therefore it has not been possible to make real changes overnight in these systems, and we'll probably see the background when nobody knows where we are in a year from now, and as to the pandemic. For sure, it will be something that will be considered when new systems are designed, but it just has not been on the agenda as far as we know from what we hear from the sources in the report.
Thank you, Frederik. I would actually like to put forward a question, also a little bit other type of question. You were also mentioning the huge investments that are needed, and we know that there are big costs connected to the digitalization of the courts. But how would you then communicate this to the taxpayers? And how would you briefly describe the benefit of digitalizing the courts, I mean, for a taxpayer?
I think that and I'm sure that there might also be input from the other participants here. But I think it is very striking that when it comes to the digitalization of administrative procedure and the state procedure in the individual countries, the digitalization has gone very far, and automatized processes are very common. But the courts, sometimes they're part of the administration as well, like here in Estonia, but still they're separate and a bit more conservative, not that open to new ideas as the general administration is set with, put extremely simple. So I would suggest that in communicating the need for developing the courts, there can be made references to the way that the administration has been improved in the countries, and state that there it has been considered a great advantage, and in the long run it is something that can save the parties the money. I think that the main transformation is still going on. The fact that we give up the ordinary mail in the court system is extremely important, because the way court proceedings are conducted is basically by sending mails forward and back. You can call it a letter, you can call it a legal document which is sent forward and back. Whatever you the structure of the court proceedings on a written basis has been letters sent forward and back, And when this is changed into, when Iceland also at some point get a case handling system, and Sweden is also fully integrated with a case handling system, then the possibilities open for changing the way that court proceedings are proceeding. And as mentioned before, the experience not only from Scandinavia but also from, for instance, the US is that it reduces mistakes. It makes the whole case handling much more simple. That you upload documents, that you work in the portals, that you give up the old way of doing court proceedings.
Thank you, Frederik. Eva, would you like to add something?
Thank you. Just very briefly, and just that you have to remember also there are different types of proceedings. I mean, civil, criminal, and administrative. We just take the basic. And for example, in the Swedish system in civil proceedings, we have a principle of orality and immediacy. So, and the trial is considered oral and immediate and concentrated. And the written phase, which Frederik is talking about, is only the preparation for the case. So, of course, and so it's important when you talk about digitalization, which step you're talking about and what you mean with digitalization in each of these phases. Some of them can assist our courting being efficient for the users, but also for the court officials generally. But other elements are more difficult when we talk about the trial and oral hearing and rendering justice. Then we are maybe conservative for a reason, because that might be different than other administrative functions. I'm not saying that it is, but it might still be different. So that's just a very brief observation.
Thank you, Eva. And Christine?
Yes, I just wanted to point out that Iceland did some work already in 1999. Then Iceland had this Supreme Court started this database with the case law. So access to case law has not been a problem in Iceland from 1999. So, but that goes with the access to information, which is a really important thing here in Iceland. And it goes along with increasing trust to the court system too. So this all goes together. So digitalization in the courtroom. So I think, and the administrative, they have been funded. So they have been digitalized, and they have started this portal, Iceland.is. And I think I've heard that they are discussing to connect this database, the portal, to the courts too. So it's going to be a big one portal, Iceland.is. So that's the future, but it takes time.
Thank you, Christine. Kaidi, would you like to add something?
I totally agree with Christine and Frederik about the benefits, what the new ICT solutions gives to society, to court users. But about investments and all the money which goes into the developments in Estonia, we mainly, at least in the Ministry of Justice, mainly we develop our systems with EU fundings. So everybody is just happy if we are able to get investments from EU funds for that. And as every ministry has its own or shared public IT company with its own budget, then it is like a normal budgeting system that we have some money for ICT developments.
Very good. Thank you. Are there any pressing questions? Otherwise, since time is running out and we need to wrap up the seminar for today. I'm sure that this discussion will continue in other fora and that we will see more research in this field. On this last note, I can mention that the Nordic Ministers for Justice will continue their focus on digitalization of the public sector with a research report on digitalization and the rule of law in the Nordic Baltic countries. We are hoping to present the results of this report in 2024 or early 2025. More information on that report will, of course, follow. On behalf of the Nordic Council of Ministers, I want to thank all of the speakers at this seminar and all the persons that have contributed to making this seminar happen. And special thanks to Mrs. Kaidi Lippus of the Ministry of Justice in Estonia and to the Tallinn Circuit Court and the staff for hosting the event both physically and digitally. We are really grateful for your valuable assistance. I would also like to thank all of you who have participated today, live here in Tallinn or online, for your interest in the report on the digitalization at the courts and for your contributions to the discussions. You will all receive the final report in an email after the seminar. So, finally, I wish each and every one of you a wonderful day. Thank you.